give it.
I'll hide it. Well, thank you. I always feel better when we get applause at the front end. I am very honored to be back again with you today. I am Mike Gilhart. I'm the scholar in residence here at the National Constitution Center. And I want to welcome you, of course, back to the National Constitution Center and today's wonderful program. As usual, since I now have to play my Jeff Rosen part as well, I want to just add a few plugs, if I may. To begin with, next week we're going to host Barry Lynn of New America and Ganesh Sitaraman, former counsel to Elizabeth Warren, and author of Middle Class Constitution for a discussion on economic equality and the Constitution. And later in the spring-summer season, we will explore some of the most important constitutional issues at the center of public life, which of course is what we do here, including Judge Gorsuch's Supreme Court nomination, the rise of fake news, James Madison's vision of freedom, and the future of Congress. That sounds like a good schedule.
Does that mean Gorsuch's nomination is fake news?
I'm sure there's a relationship. And so please visit constitutioncenter.org/debate or pick up a copy of the program schedule at the registration table on your way out for more information about these events. And we also have a number of exclusive member events scheduled for the spring. And if you're not already a member, please sign up today for access to the programs, free admission to daytime programs, and more. And of course, now take a moment to silence your cell phones, because we don't take any calls here. And now to begin today's program. It is my great pleasure to be able to welcome to the National Constitution Center Geoffrey Stone, who is, of course, a leading constitutional scholar and is the Edward H. Levy Distinguished Service Professor at the University of Chicago. He has formerly served as Dean of the Law School and Provost of the University of Chicago. He is the author of numerous books on constitutional law, including Perilous Times, Free Speech in Wartime, and publishes regularly in the New York Times and Huffington Post. Today he's here to discuss his newest book, Sex and the Constitution, Sex, Religion, and Law, From America's Origins to the 21st Century. And there'll be a book sale and signing with Geoffrey downstairs in the lobby afterwards. And of course, most importantly, I should tell you that Geoffrey Stone is my constitutional law professor, my friend and mentor, and I couldn't be happier to welcome him here to the National Constitution Center. Thank you. So it's quite a title. It's an extraordinary book, and it takes us on an extraordinary journey, really, sex, religion, and the Constitution. And I think a great place to begin is with what you say in the prologue and also at the end, how we're in the midst of a constitutional revolution. We all know we're in the midst of something. What kind of revolution are we in the midst of?
Well, the particular revolution I'm referring to in that respect in the book is that basically since the late 19th century, the United States, in its regulation of sexual activity and related behavior, has very much allowed its secular law to become dominated by religious precepts. And that since the late 1950s to the present, there's been a strong pushback against that. And first thing I guess I'd say is that it's important to understand that the development in the late 19th century was a dramatic change. If you go back to the world of the framers, there were no laws against obscenity. There were no laws against contraception. Abortion was perfectly legal. Although sodomy was illegal, the laws against sodomy were never enforced against consensual sodomy. And it really wasn't until the late 19th century that all the laws that dealt with issues like sexual expression and abortion and contraception came into effect. And since the 1950s and 60s, basically what we've seen is an effort to bring ourselves out from under that religious domination of the secular law, a domination that, in my view, is incompatible with fundamental precepts of the Constitution. And it's a revolution that's been brought about by both social movements as well as by the Supreme Court.
And of course, that revolution is not just ongoing, but we want to sort of go back almost to the beginning, if we can. And you do that in this extraordinary book you've written. It takes us even back to the ancients, in the beginning of Western civilization. So it may help us to put all this in perspective, to think about how it began, and then we'll kind of work our way back up to the present. So for the Greeks and Romans, how did they deal with sex?
Right. So the reason the book starts with...
You know part of the answer to that, but anyway, yeah, sorry.
with Greece and Rome was really to give a measure of comparison. Because the assumption of many people is that, well, the attitudes about sexuality in the United States in, say, the 1950s is the norm. And that what we're seeing now is a complete departure from historical norms. And one of the things that I learned myself, because I was not an expert on much of this history, was that was completely false. And that throughout history, attitudes about sexuality and laws about sexuality were completely different from what they became in the United States in the early years of the 20th century and the end of the 19th century. And so with the Greeks and Romans, they had an attitude towards sexuality that was completely different from the one that we came to think of as relatively normal in the United States. They had no concept of sexual sin. They did not believe that sex was shameful, that it was inherently inappropriate, and that in their world, contraception, abortion were perfectly legal. There were no laws against sexual expression or obscenity. Homosexuality was commonplace and not considered inappropriate. And it was only really, at least in Western culture, with the advent of Christianity, that we saw a dramatic shift in the attitudes of society. And even there, it took a long time for the church to begin to try to impose its values, not only upon the faithful and those who chose to be within the church, but to adopt the secular law as a way of requiring people who did not share the faith to lead their lives in accordance with those precepts. That didn't happen until well into the Middle Ages. And so the reason I start with the Greeks and Romans is really to say there is this other world that did exist that actually looks a lot more like our world today than we ever would have imagined. And in some sense, it's taken us a very long time to get back to the world of the Greeks and the Romans.
And as we set the stage for the framers and of the Constitution, we want to, of course, acknowledge that as the United States itself, or the early nation, gets populated, it's populated initially by the Puritans, and that early period of the colonies and pre-Constitution itself is a period in which religion begins to play a role in American life.
Right. So many people have the understanding that when you think about the American colonies, you got to think about the Puritans. And that the idea of puritanical attitudes and values and religious tenets about behavior, sexual as well as others, was commonplace in the American colonies. It turns out that's completely wrong as well. That the Puritans did come here to escape the Enlightenment, and they came here to establish what they called a city on a hill. It was meant to be the ideal community for people who were faithful. And it was indeed everything that we think it was in terms of the severity of the restraints that they placed on sexual and other immoral behavior, including the stocks and executions and so on. But the fact is that was a small part of the American colonies. It disappeared by the late 17th century. Basically, it failed. And the colonies were very much the product of the Enlightenment, not of the Puritans. And by the time we get into the 18th century, the American colonies were very much like Western Europe. They were in an era where the pursuit of justice and the pursuit of liberty and the pursuit of happiness were central to the way the law operated. And so the idea of the Puritans was, even to the framers generation, a kind of idiosyncratic memory. And so when the framers were adopting the Constitution, they did not have any sense of the possibility that the state would interfere with the freedom of individuals to engage in sexual expression or abortion or contraception and the like. This was, in their world, taken for granted. And so it was a very different kind of a world. People ask me, why didn't the framers put in the Constitution constitutional rights to things like sexual expression or abortion and so on? And one of the reasons is because it didn't occur to them that anybody would make those things illegal. There had not been the kind of history in their world of repression with respect to those rights, which they regarded as perfectly apt parts of their freedoms. And if you had said to the framers, how would you feel about laws being adopted that prohibited sexual expression or that prohibited abortion, I think they would have been horrified. They would have thought, my God, this is going back to the world of the Puritans. That's what we've been coming out from under for 2 centuries. So they took it as a matter of for granted, as it continued to be for another century, that these were rights of the people.
And of course, as you point out in the book, and as we know, the Constitution says nothing about sex. And And yet, you also suggest in the book that we become a Christian nation. So how does that come about?
So I don't believe we've become a Christian nation. I think there have been times in our history, first during the Second Great Awakening in the early years of the 19th century, and then quite dramatically during the period since 1980 of the moral majority and the rise of the Christian right, where the claim that this is a Christian nation has been made, and that departures from the tenets of Christianity are departures from American values. And that is both factually and historically completely erroneous and dangerous. Again, the members of the framing generation, those who created our Constitution, were very skeptical about traditional religious beliefs. Most of them, not all of them, but most of them were not in fact practicing Christians. Many of them were deists. They believed in a God, but it was a God that had no values other than do unto others as you would have them do unto you, which is what the basic religious principle of most of the framers was. And the notion that this is a Christian nation has no basis in fact, if by nation we mean how we were created and what the aspirations of the nation were. The aspirations of the nation instead were captured in the First Amendment, which required a separation of church and state. It recognized that a fundamental right is people who do have religious faith should be allowed to practice their religion, and that the state should not, without substantial justification, should not interfere with the freedom of individuals to practice their religions. But equally important and compelling was that the state should not itself take a position on religion and should not adopt laws, the purpose of which is to impose upon individuals the religious beliefs of others. And indeed, in the early 19th century, during the Second Great Awakening, when sort of like the moral majority, evangelicals began taking on a much more active and effective political role in American history. And they began, for example, adopting laws against blasphemy and trying to enforce those laws, or trying to adopt laws against Sunday mail delivery, which had always been legal before. People like Jefferson and Adams were horrified. And they strongly opposed this and objected to the idea that these kinds of religious movements incorporating the secular law were completely incompatible with the understanding of our Constitution.
We're going to go back to that 19th century then. And so, as you point out, there's some forms of regulation begin, and they're going to include regulations of abortion as well. So, if you don't mind, walk us through some of the kinds of regulations that we see in the 19th century.
So, up until the late 19th century, and throughout the history of Western culture, there were never any laws prohibiting abortion post-quickening. And quickening is basically defined as the time when woman first feels the movement of a fetus, roughly about 4.5 months. There were prohibitions on abortion after quickening, but they were rarely enforced. But pre-quickening, from the era of the Greeks and the Romans all the way up to the late 19th century in the United States, there were no laws against abortion in the first half of pregnancy. And that was taken for granted. That began to change in the latter part of the 19th century, really because of a combination of two events. One was a change in the evangelical Protestant view of when life begins. The traditional view of evangelical and Protestants, unlike Catholics, was that life did not begin until quickening. But in the late 19th century, they began to change that, mainly because of the born-again movement. With the born-again movement, Protestants or evangelical Protestants began to take the view that you can be born again in an instant. At that moment, when you have the awakening, the realization of who you are transformed. And they began to argue that that moment occurred at conception, not at quickening, and wanted then to impose that upon the law. And the second thing that happened at that time was the birth of the American Medical Association, which had not existed before, and a number of religious zealots, frankly, played a large role in the framing of the AMA. And one of their central precepts was this notion that life begins at the time of conception, that women are incapable of making decisions about how to deal with themselves when they are pregnant, because when they're pregnant they are deranged. That many women who have abortions later commit suicide because of their regrets. And they sort of put this out there as a matter of what they regarded as fact. And by the end of the 19th century, every state in the nation had adopted laws against abortion. Similarly, with obscenity, there were no laws against obscenity in the United States. There was no such thing as the concept of obscenity in the colonies or in the United States. During the Second Great Awakening, a couple of states adopted laws against obscenity, but they were relatively rarely enforced. It was after the Civil War that Anthony Comstock became a leading figure in the social purity movement, which basically maintained that the availability of sexual expression had a serious impact on morals and on moral behavior, that it corrupted youth, that it caused the breakup of marriages, that it caused premarital sex, which led to pregnancy, which led to abortion. And that led to a very powerful movement to ban obscenity. And by the end of the 19th century, again in the same time period, every state in the nation had adopted laws against obscenity. And the concept of obscenity that existed then was extraordinarily broad. It included basically anything that referred in any way to sex. So anything about contraception, for example, became illegal. Any use of a word like pregnant or penis or vagina was illegal. And that was something which people began fighting about and fighting against in the late 19th century. But by the time you got to the 20th century, basically the laws against obscenity in the United States prohibited any reference to sex at all. And even when we think back to the 1950s, by the way, if you think about television, for instance, right? I mean, that was kind of a reflection of what the world was like under obscenity law in the United States in the late 19th and early 20th centuries. You know, even to the point that Elvis couldn't be filmed right below the waist when he was dancing, because that was seen as too sexual. That's kind of what the law was generally in the United States, and that change took place from roughly 1870, 1880 to 1900, and then gradually began to dissipate during the 20th century.
And so I want to pick up on one other theme that I think might be running throughout part of the history that you're sort of reviewing with us, and that is the extent to which the law is treating women different than men. To what extent is the law defining women perhaps in an inferior way to men and treating them as such?
Right. Well, particularly with issues like abortion and contraception, as well as with issues like obscenity, a part of the religious conception was the notion of Eve, the idea that woman is a source of temptation and is driven by sexual desire, and that woman can't be trusted. And so just as there was a fear that if children are exposed to sexual expression, it will lead them to behave in certain immoral ways, there was similarly a belief that if women are able to have access to sexual expression, it will cause them to become Eve-like and to corrupt men with their sexually salacious behavior. And similarly with issues like contraception and abortion, there was a concern that if women could have sex without the fear of pregnancy, then, as it was often put in the late 19th century, what would keep them chaste, right? And that the need to ban contraception and the need to ban abortion was in part justified by the desire of men to make sure that women did not exercise their natural sexual impulses in ways that would be both harmful to society and, more importantly, harmful to the men with whom they had relationships.
And so this is our story. This is American story. And so as we move into the 20th century, there's going to be another branch that gets involved in this story, and that's courts. They're not playing, obviously, much of a role with respect to much of this in the 19th century. 20th century, it's going to change to some extent, and it first changes with regard to obscenity and freedom of speech. So perhaps it'll be helpful to get a sense of how the courts first deal with these issues in the early 20th century.
Right. So no one took the position that laws dealing with sexual expression, obscenity, violated the First Amendment until well into the 20th century. There were occasional civil libertarians who would make the argument, but it basically wasn't taken seriously. To the extent there was a constitutional guarantee of free expression, whatever it meant, and it was still largely ill-defined, nobody really seriously thought, except for a few really very strong civil libertarians, that it had anything to do with sexual expression. But nonetheless, a number of judges in the early years of the 20th century began interpreting the laws against obscenity in a more narrow way. They began basically interpreting it interpreting those laws so as not to reach anything that included contraception or anything that included words that had sexual connotations. So courts began recognizing that these statutes, which prohibited sexual expression, should be interpreted more narrowly than they had been in the past, and began making arguments about the reason for interpreting them more narrowly was because we value free expression. But it wasn't until 1957 that the Supreme Court first addressed the question of whether regulation of sexual expression is protected by the Constitution. And what the Supreme Court held in that case, in Roth versus United States, was that there is a concept of obscenity that is outside the protection of the First Amendment, but that it has to be carefully defined, and that it has to be defined as speech that appeals primarily to the prurient interest in sex, that depicts speech in a way that is offensive to contemporary community standards, and that lacks any redeeming social value. And in that decision, the court began for the first time as a First Amendment matter to put limits on what could be prohibited in the realm of obscenity. Now, even so, in 1957, the court's conception of what was obscene was still pretty broad by our standards today. And laws that showed any serious nudity, for example, would immediately be suspect, even in 1957, if that nudity showed people engaged in sexual behavior. But it had moved well beyond the earlier generation, where, for example, books like Lady Chatterley's Lover could not legally be sold or obtained in the United States under obscenity laws. That understanding of obscenity, the court in 1957 rejected. And since 1957, as social attitudes about sexuality have changed, partly because of changing social attitudes, partly because of changing technology, the concept of obscenity has narrowed consistently ever since that time.
And of course, the 1950s and 1960s end up being very important, not just for freedom of speech, but that's going to be when the Supreme Court first begins to consider some issues and turn out to be seminal cases that deal with sexual behavior. First in Pohl versus Ullman, and then of course in Griswold.
Right.
So Griswold becomes a foundational case for us in the 1960s. What difference does it make? What's its significance?
So Griswold is a case involving laws prohibiting the sale, possession, distribution, or use of contraception. And these laws were everywhere in the United States by the turn of the 20th century. They had begun to be repealed through the 20th century, but even as late as 1965, a number of states still had such laws, including Connecticut. And in Griswold versus Connecticut, the court considered whether those laws could constitutionally be applied to married couples. And the Supreme Court held that such laws were unconstitutional, that the right, at least of married couples, to make decisions for themselves about matters as fundamental as whether to bear or beget a child could not be interfered with by the state without a much more compelling justification than the arguments that could be put forth for banning contraception. And Griswold was a revolutionary decision because it recognized for the first time explicitly that the right of individuals to control decisions about reproduction was a fundamental right under the Constitution that the state had to respect, much the way it had to respect rights like freedom of speech and freedom of religion, freedom from unreasonable searches and seizures, and so on. And it was Griswold that laid the foundation later, ultimately, for Roe v. Wade. The next step in that progression was a case called Eisenstadt versus Baird, decided 7 years later, in which the question was whether a state could prohibit unmarried people from having access to contraception. And in Eisenstadt, the court held that those laws were also unconstitutional, that the state could not prohibit unmarried people from having access to contraception, that again, the freedom to make decisions oneself about reproductive judgments, about whether to bear or beget a child, are so fundamental that the state cannot interfere in that manner. And Eisenstadt was the next major step towards Roe v. Wade.
And of course, what we're talking about now is not a conversation that's unique to this forum. You might have even heard it not too long ago on television in the Senate Judiciary Committees, when the Senate Judiciary Committee itself was questioning Judge Neil Gorsuch, President Trump's nominee to the Supreme Court, about his view on precedent, how he'd approach it, how he'd consider overruling cases. And Griswold, of course, is one of those seminal cases that is in the line of cases that leads up to the court's 1973 decision in Roe versus Wade. And is that case a surprise to some extent, the way the court comes out on that? It certainly makes a big difference in terms of constitutional law, in particular with regard to a notion known as substantive due process. But Roe comes down in 1973, an early Burger Court decision.
Right. So I actually was a law clerk for Justice Brennan at the year that Roe v. Wade was decided. And the thing about Roe, which is fascinating, which people today don't recall or know, is that at the time it was decided, it was not all that controversial or big a deal. The fact is it was a 7-2 decision. 3 of the 4 Nixon appointees joined the majority in Roe v. Wade, even though they had been appointed to be conservative justices only a few years earlier. And at the time Roe v. Wade was decided, it wasn't even the lead story in most newspapers. Lyndon Johnson happened to have died the same day Roe was decided, and that was the big story. And newspapers across the country basically approved of Roe, including in southern states, including in states like Georgia and Texas. And the vast majority of the American people approved of Roe v. Wade. Only 40% of the American people disapproved of the decision. And it's interesting to compare that, for example, with the reactions of the American people to a number of other decisions, like the decision holding school prayer unconstitutional, or the decision holding laws against mixed race marriage unconstitutional, or Citizens United, in all of which 70 or 80% of Americans disapproved of the decision. So the fact is, when Roe was decided, it was important, obviously, and it was intellectually a difficult case. But in terms of the popular response to it, it was very largely positive. And the kind of response that we now see that developed at the very end of the decade, which is driven very much by, again, the Christian right and the moral majority, which came into existence not just because of Roe, but also because of a reaction to the gay rights movement, to the Equal Rights Amendment, which was then going on, changes in family relationships, changes in sexual relationships around the country. And Roe became a target of that. But it is interesting to understand and to remember that when Roe was decided, it was simply not seen as that big a deal. One interesting insight into this is that the court received a huge number of letters immediately after the decision, all from basically Catholic school students in parochial schools, which were basically form letters that their teachers obviously dictated to their students. And they came in huge numbers. And the court is not used to getting large amounts of mail. And so there were boxes and boxes and boxes of these form letters in the hallways. And nobody was really interested in reading them after you realized what they were. Most of them were addressed to Justice Blackmun, who wrote the majority opinion, and Justice Brennan, who was the court's only Catholic justice. And they were what you would call hate speech today. But the only people who were interested in reading them were the law clerks who had been traveling around the country to interview for jobs the following years and were waiting for reimbursement checks from the law firms. And so they were spending until 3 in the morning going through these boxes and boxes and boxes of mail looking for their reimbursement checks.
Hopefully they found some.
I hope so.
Another indication, by the way, of how, at least initially, the public or political reaction to Roe was, I guess you could describe it as delayed, is if you look at the confirmation hearing for one of the first justices nominated right in the aftermath of Roe. It's John Paul Stevens, nominated to the Supreme Court by President Ford. And there's a grand total of 0 questions about Roe versus Wade. Mm-hmm. That's going to change. And now we have to think about how it changes and what the changes are. So Roe, of course, becomes a target. And it particularly becomes a target when President Reagan comes into office. He's very open, transparent about it. He says he's going to appoint justices who are going to be devoted to dismantling Roe. So, of course, that effort unfolds, and then the next big case we get is Casey. Happens in election year. And what happens in Casey?
Right. So before Casey, one of the ways in which the politics of Roe changed is it's interesting to note that before 1970 or so, Republicans were far more pro-choice than Democrats. And the reason for that was most Catholics were Democrats. And in the late 60s, Richard Nixon figured out that he could draw Catholics into the Republican Party by becoming anti-abortion. And before then, Republicans like Barry Goldwater, Ronald Reagan, and Richard Nixon were actually pro-abortion in the 1960s. But Nixon changed that as a strategic way to bring Catholics into the Republican Party, and it was quite successful. One of the reasons he won the 1972 election against George McGovern with such a huge majority is for the first time a majority of Catholics voted for the Republicans. And what Richard Nixon then figured out, what Ronald Reagan then figured out is that Protestants who basically divided in their votes between Republicans and Democrats, including even evangelicals, that by bringing the moral majority into the Republican Party, he could strengthen the Republican Party even further. And of course that happened. And one of the reasons why Reagan won by such a large majority in '84 was because of his support from Jerry Falwell and from others on the Christian right. And that led to a dramatic change in the way in which Supreme Court justices were confirmed. So Casey comes up in the early 1990s, 20 years roughly after Roe. And by this time, Republican presidents, including Reagan and Bush 1, have managed to make a majority of the appointments to the Supreme Court. And by this point, I think it's 7 of the 9 justices were appointed by Republican presidents. And Casey comes to the Supreme Court, and the question in Casey is basically whether certain types of regulations of abortion are constitutional. And the fundamental question that's really being raised is whether Roe should be overruled. Reagan had certainly strongly taken that position, and a number of Supreme Court nominees, upon reaching the court, like Scalia and Thomas, had made clear that they were in favor of overruling Roe v. Wade. And the expectation was that the court in Casey would overrule Roe v. Wade. On the court at that time, one had Scalia, Thomas, Rehnquist, Kennedy, O'Connor, and Souter. And the expectation was they would vote to overrule Roe. And after Roe was argued, that's what everybody thought would happen. And then Justice Kennedy sends a note to Justice Harry Blackmun, who was the author of Roe and was still on the court, and said, we need to have a conversation. I have something to talk about. And what he basically told Blackmun was that he and O'Connor and Souter, all Republican appointees, all appointed by either Reagan or Bush 1, had basically decided that there was a Supreme Court obligation to respect precedent that was compelling in the absence of a very good justification for overruling precedent, and they did not see any good justification for overruling precedent. And the fact is, they also read a bit about the history of the world before Roe v. Wade. And that history gave them a fuller appreciation of what would happen in the United States if Roe were overruled. And going back to the world in which a million women every year were either self-aborting or going to back alley abortionists, where hundreds of women were dying every year because of botched abortions, with one which was they understood was not really a world in which they wanted to put this country. And so, to the shock of the presidents who'd appointed them, and to many Republicans, the 3 of them wrote an opinion in Casey, which basically reaffirmed Roe. It made changes in the decision, but fundamentally it reaffirmed its core precepts. And because of that moment, the right to abortion continues to this day.
So I want to talk about those core precepts just for a moment, just because there's going to be a test. And get a sense of what is the basis for cases like Roe, and particularly Casey, and what's the dissent arguing in these cases? Because I think it will help enrich our understanding of what the nature of the constitutional dialogue is here.
Right. So there are basically 2 primary arguments against cases like Roe or Casey. The first one, and the most basic one, is that there's no such right. There's simply no right to an abortion. Show me it in the Constitution. It simply doesn't exist, right? And did the framers affirmatively intend there to be a right of abortion? Show me the evidence of that. Nobody said a word about abortion, not once, when the Constitution was being adopted or when the Bill of Rights was being ratified. So the argument is, this comes out of whole cloth. It doesn't exist. It's not existed. You just made it up. the response to that is fundamentally the question about unenumerated rights. That when the framers, in the original Constitution, there was no Bill of Rights. And one of the reasons the framers of the Constitution did not include a Bill of Rights was because they were concerned that if they did so, the assumption would be that the rights that were listed would be the only rights that people possessed. And they did not want to create that implication. Nonetheless, after the Constitution was put up for ratification, there were very strong objections to the absence of a Bill of Rights, and we went back and then added the Bill of Rights as a series of amendments. And one of the key factors in those amendments was the Ninth Amendment, which basically says that the enumeration of rights in the Constitution shall not be taken to abridge or deny the existence of other rights that are held by the people. And the whole point of the Ninth Amendment was to recognize that the list of rights in the first 8 amendments was not to be understood to suggest that there were not other rights. The framers understood full well that, first of all, they weren't going to try to list every right that people had, and second of all, that with time, there would both be efforts to restrict rights that they took for granted, that they didn't even imagine needed to be enumerated, and second of all, that society would change in ways that it would become evident that certain things needed to be acknowledged as rights, even though they themselves might not have thought about that. These were, at the time of the framing, men. They were men of the Enlightenment. They understood that knowledge changes, that people learn over time, that society evolves, and they wanted this to be open-ended intentionally. So in a case like Roe or Griswold, and in a host of other decisions, the Supreme Court over time has recognized that part of its responsibility is not only to enforce the explicit guarantees of the Constitution, but also to recognize that those explicit guarantees are not an absolute limitation. And the notion that individuals have fundamental rights, for example, to marry, a right to have children, a right to make fundamental decisions for themselves about whether to have or not to have children, and a host of other areas, the court has recognized that these fundamental rights exist. That's what the court did in Griswold. That's what it did in Roe v. Wade. The second argument that's made is that, well, even if there's a right to marry, even if there's a right to control reproduction, there can be such a compelling government interest on the other side to override that right. And the compelling government interest is you're killing an unborn child. And killing an unborn child is such a powerful state interest to prevent that, that even if there's a right to control your own reproductive freedom, and even if there's a right to have contraceptives, you can't have an abortion. And what the court said there in Roe is, look, there is no way to know when life begins, when human life begins. The argument that's being made is derived from a religious precept, from a religious understanding. We cannot restrict fundamental rights because certain people have a religious belief about such a matter. That's not consistent with the separation of church and state. That's not consistent with the way our Constitution operates. And therefore, even though some people may believe sincerely that an unborn fetus is a human life, and therefore they shouldn't have abortions if they don't want to, they cannot impose that belief on others in such a way as to restrict the fundamental freedom of other people.
And of course, there's another critical line of decisions we're going to get to in just a moment that's almost paralleling this, the court's consideration of abortion as a possible fundamental right. It may be helpful also to sort of just round out the discussion of this dialogue, just to understand what the nature of the dynamic is in these cases that come before the Supreme Court. When the court's being asked, is this particular interest a fundamental right or not, is the court in some ways is being asked whether or not it should make that decision or it should leave it to legislatures. There's a trade-off to some extent. And so if the court says it's not up to us, it goes to legislatures. And then they make decisions whether or not to regulate abortion, or now we move to the second line of decisions, whether or not we should regulate certain kinds of sexual activity, such as homosexual sodomy. And so there are a line of cases, beginning with Bowers versus Hardwick, moving to Lawrence, in which there's sexual activity, which is the focus. What's happening in those cases?
Right. So, again, the more general point is, why do we have courts to interpret the Constitution and apply the Constitution? The framers understood that if you put rights in the Constitution and you then leave them to the majority to interpret, you're not going to put any serious check on the majority. And the framers didn't trust majorities. they understood the dangers of democracy, and they worried a lot about the possibility that majorities at any given point in time would behave in ways that were incompatible with the fundamental rights and liberties of the people. And so one of the reasons to have a Supreme Court in particular with life tenure is to insulate the justices from the pressures of the majority and to give them the responsibility and the courage and the opportunity to enforce these guarantees even when the legislature, acting on majority demands, is behaving in ways that are inconsistent with what fundamental rights are meant to be guaranteed. And two of the ways in which the court tries to figure out where it needs to play a particularly important role, one of them, which the framers were acutely aware of, is the understanding that majorities will often be intolerant and oppressive and discriminatory and bigoted because of prejudice that is built into the culture, and they will treat unfairly groups that have been historically disadvantaged and discriminated against and undervalued. And that majorities should not be trusted when they're acting in those realms. And the second had to do with circumstances not particularly relevant here, where majorities, particularly legislatures, pass laws that have the effect of perpetuating their own power. That is equally critical, but it's not really relevant so much in this context. But the first one's very relevant here. And in situations like, let's say, abortion or the rights of gays and lesbians, one thing that the court is very sensitive to is the fact, for example, only women can have abortion. Right? It's an old cliche, but a powerful one, that if men could get pregnant, abortion would be legal. Right? And laws against abortion clearly are based upon a certain view of women, reflected in what I said earlier about the attitude in the 19th century, about women are deranged when they get pregnant and what will keep them chaste. And those kinds of attitudes very much have historically colored the rationale for laws against abortion on the part of people who did so not only for the religious reasons, but for others. And that the protection of the rights of individuals, of women in particular, to choice in this respect, is partly protecting a vulnerable group to a political system that's not likely to understand and sympathize with their plight. And obviously even more so with respect to gays and lesbians, that they have historically been oppressed and discriminated against. And once the court came to understand that, it's a great example of the evolution of understanding. Once the court, like society, began to understand that homosexuals were not like burglars, the way they often have been understood. That is, they're not simply people who choose to be criminals, right? They are a class of people who have an immutable characteristic that is fundamental to their identity, and who are in fact doing nothing that deserves their being discriminated against and harmed. Then the justices understood that this aspect of judicial review, of protecting groups like that, whether they be blacks or women or gays, from laws that are fundamentally discriminatory, is a core part of their responsibility. And so in cases like Lawrence v. Texas, where the court held for the first time that laws prohibiting same-sex sex were unconstitutional, the court basically understood that in this realm, states were clearly discriminating in a fundamental respect against gays and lesbians. And then in Obergefell, when the court deals with the issue of same-sex marriage, the court again says, sure, we could leave it to the legislatures, and many states may in fact, the blue states may in fact allow same-sex marriage, but we're not stupid. We know that in half the states this will never happen, or at least not happen for a very long time. And in the meantime, even if it does happen over the next 100 years, hundreds of thousands of gay couples will be denied the fundamental right to marry. That's not acceptable. And that's why the court was right in making its decisions in Roe and in Obergefell.
And of course, we're almost to the right to marriage in Obergefell. I'm going to sort of again play devil's advocate to some extent here, return us a little bit to some of the dissents in these cases, and obviously your former colleague, Antonin Scalia, Justice Scalia, who's dissenting in a number of these cases, including, of course, Lawrence versus Texas, in a very, very heated way. And I'm asking this in part because a number of the questions I've gotten from the audience are about originalists and how originalists approach the Constitution. One argument, of course, Justice Scalia is going to make in the case in his dissent is, well, original meaning should control how we dispose of these cases. There's nothing to find in original meaning that would support recognition of these rights, whether it's Roe or Lawrence. Is he getting originalism wrong? Is originalism irrelevant? How does originalism come into play here?
So the modern version of originalism came into being in the following way. During the Warren Court, which was regarded as very activist, meaning it did not give deference to the majority in deciding on the constitutionality of laws, but was pretty aggressive about interpreting the Constitution to invalidate laws, basically when they did one of two things. When they either harmed groups that were not able effectively to protect themselves in the political process, and when the laws were designed to perpetuate the power of the people who were passing those laws. That explains much of the Warren Court jurisprudence. But conservatives did not like that. They did not like school prayer decisions. They did not like the decisions about Miranda. They did not like decisions about the exclusionary rule. They did not like decisions about holding unconstitutional laws against interracial marriage. And so when Richard Nixon ran for president, he promised to appoint justices who would be strict constructionists. That is, they would narrowly construe the Constitution and give great deference to the majority. The problem with that approach, which conservatives of integrity like Robert Bork and Antonin Scalia understood, is that for the justices to give deference to the majority across the boards would be abdicating a fundamental responsibility that the framers of our Constitution wanted the justices to exercise. That is, protecting our citizens against abusive decisions by majorities. And so the question was how to both maintain a degree of judicial restraint while at the same time fulfilling the responsibility that courts have to enforce the Constitution. And so they came up with this idea of originalism. And the idea was basically that courts should only strike down laws that the framers of the Constitution affirmatively intended to be unconstitutional when they were adopting these open-ended provisions of the Constitution. And if the court limits itself to that, then it's fulfilling its responsibility, but it's not reaching out and basically doing what the conservatives thought the Warren Court was doing, was substituting their own personal political values for the real meaning of the Constitution. Now, there are at least three objections to originalism. The first and the most important is that it's completely internally inconsistent. Because the rationale of originalism is we are going to do what the framers wanted us to do. But the last thing in the world the framers would have wanted the justices of the Supreme Court to do was to be originalists in that way. They were, as I said earlier, men of the Enlightenment. They knew they were drafting vague, open-ended constitutional guarantees. They didn't know what those guarantees meant, frankly. They didn't try to specify what they meant. They understood that these vague guarantees would evolve over time and should evolve over time. So an originalist would have to be a non-originalist. So the first difficulty with originalism is it actually makes no sense to the extent its purpose is to be faithful to what the framers wanted. The second problem with originalism is that there are cases you can decide from an originalist perspective in a relatively straightforward way. That is, did the framers affirmatively intend there to be a right to abortion? Did the framers affirmatively intend there to be a right of same-sex marriage? No. You cannot say that they, in their own minds at that time, explicitly thought that that's what they were doing. It never occurred to them. There was no reason for it to occur to them at that time. So those decisions would come out the way Scalia would like if you applied originalism in that way. But the problem is the vast majority of issues actually don't have such simple answers. Because the truth is, in the vast majority of cases, the framers didn't think at all about these questions. And so if you look at what the so-called originalists actually do when they decide cases, particularly justices like Scalia and Thomas, is they kind of ask themselves this. Well, let's see. The framers were reasonable people. I'm a reasonable people. If I were an originalist, what would I have thought? This must be what the originalists thought. And this is therefore what the Constitution means. And the third problem with originalism is that justices like Scalia simply could not exercise the discipline necessary to make it credible. So in Scalia's own jurisprudence, He is happy to advocate originalism in those cases, like those dealing with issues of abortion or gay rights or same-sex marriage, where it supports his conclusions. But then he turns around and he says affirmative action is unconstitutional. Gun regulation, gun control laws are unconstitutional. Campaign finance regulations are unconstitutional. The Voting Rights Act is unconstitutional. No originalist could possibly reach those conclusions. They're not in any way sustainable from an honest originalist perspective. So the truth is, even the so-called originalists have not been able to discipline themselves to be originalists. And the consequence of that, in truth, is that originalism as a theory has largely been discredited. And although there are academics who continue to play with it and think about it and try to enrich it in ways that are interesting, very few judges or justices actually today seriously try to apply it, because it really just doesn't work.
Well, we were going to plan a program on originalism, but we don't have to now. It's certainly a topic, a subject that's worthy of its own consideration. But to round out our story, the one you tell in your book, Obergefell, of course, is one of the more recent cases that is non-originalist. And it's a revolutionary case. So what happens there, and how does it kind of help round out your story?
Right. So in Obergefell, the court, of course, has the question of same-sex marriage. And it got there incrementally. And part of the story the book tells is how the court, over time, in this particular area, as well as others, learns from experience and responds to changing social movements and values and so on. So when the court first addresses the question of whether gays and lesbians have certain rights, it's in Bowers v. Hardwick, decided in 1986. And in Bowers v. Hardwick, the question is whether laws against sodomy are constitutional. And in a 5-4 decision, the Supreme Court holds that such laws are constitutional and that a gay couple can be prosecuted and convicted for engaging in oral or anal sex. And the remarkable thing about Bowers v. Hardwick is that it was a 5-4 decision in 1986. I mean, when you think about it, it's really kind of stunning. In 1986, only about 30% of the American people thought that laws against sodomy should be repealed. And yet, the justices, only in a 5-4 decision, were able to uphold that. But the majority treated it as self-evident. And Justice White, who wrote the majority opinion, basically treated the argument that such laws were unconstitutional as facetious, his word, in the case. And what's interesting about Bowers, it almost came out the other way, even more than the 5-4 decision. Because Justice Lewis Powell, who had been appointed by Richard Nixon, and who was a conservative, but an open-minded and moderate conservative, was the swing vote in the case. And while he was trying to figure out how to vote, he had a conversation with one of his law clerks. And he said to his law clerk, "I don't understand this thing about homosexuals. Why can't they just have sex with women?" And the law clerk explained, "Well, Justice Powell, they can't get erections when they want to have sex with women." And he says, "I don't understand that. Why can't they get erections when they want to have sex with women?" And he said, "I've never met a homosexual. I just don't get it." And the clerk tried to explain to Powell what this was all about and so on. What Powell had no idea was that he was talking to a homosexual. And that clerk, some years later, came out. And Powell ultimately was persuaded by Chief Justice Berger to go along with the majority, and later said he deeply regretted the decision. So the court was that close in 1986 to saying laws against sodomy were unconstitutional. The court didn't reverse that decision until 2003 in Lawrence v. Texas, when the justices, some because of a change in the makeup of the court, mostly because the justices had come to have different views, and society had come to have very different views about homosexuals by that time. And the court in Lawrence v. Texas overruled Bowers v. Hardwick and said that laws against same-sex couples having sex violated the fundamental rights of individuals to make those decisions for themselves. And then, of course, in Obergefell, the court deals with the issue of same-sex marriage. And by the time of Obergefell, it seemed pretty clear what the court was going to do, because 2 years earlier, it had decided in the Windsor case that the federal law on same-sex marriage, the Defense of Marriage Act, was unconstitutional. And what the Defense of Marriage Act did, among other things, was to basically say that a couple who was married in a state that allowed same-sex marriage was nonetheless ineligible for any federal benefits that were available to married couples. And that law was passed at a time when there were no states that allowed same-sex marriage, but people were worried about the possibility. And in the Windsor case, the court, in a 5-4 decision, held that law unconstitutional and basically said that such a law was so overtly and obviously discriminatory against legally married same-sex couples that it could not withstand scrutiny. And Justice Scalia, in dissenting in Windsor, basically said, and it was a furious dissent, and he basically said it's only a matter of time before the next foot falls. And indeed, he was right. And 2 years later, in Obergefell, the court said states cannot deny same-sex couples the freedom to marry. And again, it was part of this notion that the justices, or the justices in the majority at least, and again, it was a bitter 5-4 decision, came to the judgment that the freedom of gays to marry was fundamental, that the court had long recognized that the right to marry was fundamental. It had held unconstitutional, for example, laws that said prisoners cannot marry, or that a father who would failed to meet child support payments was barred from marrying. It basically had held long ago that the right to marry was fundamental, and it simply applied that in the same context. And the interesting thing about Obergefell is that although there was furious opposition to it both in society and in the Supreme Court, the reaction to the decision itself in the couple of years that have now passed has been shockingly tepid. I think the contrast between it and Roe in this respect is really interesting. And part of it is because in the context of homosexuality, there was a time when most Americans, like Justice Powell, thought they'd never met a homosexual. And they had no particular sympathy for them. They didn't know them. They were just kind of weird freaks. And because of the AIDS epidemic, gays in our country could not remain in the closet. And as a consequence, people began to learn that their children, their children's children, their neighbors' kids, their teachers, their co-workers were gay. And learning that and getting to know these people profoundly changed their attitudes about homosexuality. And as a consequence of that, attitudes about homosexuality have changed. And the same thing, I think, has happened with same-sex marriage, is that if people have come to see gay couples, much more commonly, they've just sort of lost their unease and their fury about it. Even if they don't like it, it's become more commonplace. With abortion, I think the reason the issue continues to be so burning today is that if you sincerely believe that abortion is killing an unborn child, then you can't just turn the other cheek. If a state adopted a law that said, you know what, parents can kill their kids until they reach 2 years of age because, you know, you should be able to change your mind. You know, most of the people in this room would be horrified. And for those who believe that abortion is like that, it's easy to understand why their opposition to abortion is as fierce and as persistent as it is. And although I understand that, I think they have no right to impose their belief on others. But it's easy to understand why they feel the way they do. Well,
we are we're getting close to running out of our time, but I want to at least ask one other question from the audience, and then I'm going to have one other question myself. And I should say that the audience appears to be classically educated, because I'm getting a lot of questions about Greeks and Romans. Either that or it's really interesting too. But I want to ask one of them, and that is, wasn't Socrates condemned for sexual immorality? And what about adultery and the adage about Caesar's wife? The point being that wasn't there some regulation of that activity at that time?
Right. They did have regulations on adultery where the adulteress was the woman, was the wife, not the man. With respect to homosexuality, in the Greeks, a common relationship in the Greek world was pederasty. That is, it was very common for a man to have a relationship with a post-pubescent adolescent boy. And these were not only permitted, they were highly valued, shocking as this may seem, shocking to me, frankly, to learn this. These relationships were seen as a healthy part of the way in which young men learned how to be citizens of the society. And that there was this relationship that was both sexual as well as non-sexual. And in the Greek culture, there was a sense that, as one author put it, to love truly, one has to love a man, because women aren't really worth loving. And so the pederasty was a very common part of Greek culture. Now, on the other hand, adult men who had sexual relationships with other adult men were fine as long as they were in the male role. If they were the person being penetrated, they were regarded as feminine, and that was frowned upon. But the pederasty relationship was both commonplace and, amazingly, it was kind of applauded as an appropriate way of socializing young men in the society.
So I want to come back and just remind everybody that what we're talking about today couldn't be more timely. In some ways, it's timeless. It's also timely in part because, as we know, there is a Supreme Court nomination pending before the United States Senate, and the nominee, Judge Neil Gorsuch, has embraced original public meaning. So I want to sort of push back a little bit against what you said about maybe it's losing at least some academic credibility by saying, does it at least retain some political force and some political support in today's society?
Yeah, absolutely. It's a cliche that people use in the political arena as what's seen as a fully respectable method of constitutional interpretation that rejects judicial activism when we don't like judicial activism. And so it has taken on in the political realm, I think, a great power. The same way that judicial restraint once did, and now originalism does. One problem that liberals have faced and have not been able to solve is how to come up with a similar cliche for what they regard as a legitimate and indeed fundamental and appropriate method of constitutional interpretation. And I described earlier what I think that is a method of constitutional interpretation that is focused on two fundamental responsibilities: protecting the interests of those who will not fairly be protected in the majoritarian political process, and ensuring that those in positions of authority do not manipulate the law so as to preserve their power in the political system. But there's no damn cliche in one or two words that captures that, and it's been very frustrating. But yes, I do think that originalism has kind of replaced judicial restraint, and people who champion it have no idea what they're talking about, but they think it means something they like.
Well, I think we've got a great program that we can schedule, which is what cliche should liberals have as an alternative.
Absolutely.
There's no better place than the National Constitution Center, I dare to say, for a candid civil dialogue about the Constitution, about learning about it. You've now had the pleasure over the last hour, the pleasure I've had for decades of learning from Geoffrey Stone. I want to thank him for being here. Thank you.
Thank you.